Good afternoon, everyone. It gives me immense pleasure to welcome you all, the young, enthusiastic lawyer gathered here today who are eager to learn and shape their career in the dynamic field of arbitration law. We are truly privileged to have with us Sri Dipan Merchant Sir, Senior Advocate, Bombay High Court, a distinguished senior advocate and one of the most respected names in the field of arbitration and commercial litigation. With more than 4 decades of rich experience representing clients in domestic and international arbitration matters, he has been instrumental in shaping arbitration practice in India and widely recognized for his experience in arbitration law, with a particular focus on the principle and practice of evidence before the arbitration tribunal. He has appeared in number of cases in India, in all over the world, in all the high-profile cases, and in Supreme Court and various high courts of Delhi. Dipan sir is known for his humbleness, scholarly approach, and deep understanding of complex legal issues and has been a guiding voice in the field of arbitration and commercial dispute resolution. He is also an esteemed speaker at national and international legal forum, including programs hosted by organizations such as Public Law and Legal Education Association, where he shares his insights to enrich legal education and professional practice. Sir, about you, we can say one thing. कलम से इंसाफ की इबारत लिखी है आपने, कलम से इंसाफ की इबारत लिखी है आपने, हर दलील में सच्चाई भरी है आपने, हर दलील में सच्चाई भरी है आपने. And sir, you used to say one thing to all the young lawyers, and we must remember one thing which you always convey to the young lawyer, that you need to search of yourself in your own version, and rest other things are available on Google. Thank you very much, sir. So please welcome Sri Dipan Merchant sir with a big round of applause. Thank you very much, sir, for giving us valuable time, sir. Please, sir.
Thank you, Vishnu, for your introduction. I'm also obliged to the laws which is giving opportunity for giving this arbitration lecture series on the Arbitration Act. Arbitration Act itself is a piece of art where everything under the Act, what you expect, is covered. You never realize what is required and when be required. But Act is framed in such a manner that in 4 corners of the Act, all points are covered. So it is a Bible for all of us. We are dealing with Arbitration Act itself. Everything is called like Evidence Act. The Evidence Act was a piece of art with everything, unexpected things also mentioned therein, and we'll find that answer to that. As you rightly said, Vishnu, that I always tell all my juniors also, please don't depend only on Google. You must first apply your mind, check the facts of the matter, consider the law, see the section itself, apply the provision of section itself, and then try to search some judgments if you don't find a normal course from Google. Because Google is a standard thing which is available, but they will not give you facts wise or they will not give you topic wise. So that you have to search for it. Now, as you have given me opportunity today to speak about the certain sections of the Arbitration Act. So before we go to the frame of the sections, and I was told by you that I have to give them insight of section 9, 16, 17, and 37. These are the main sections of the Arbitration Act which we use day in and day out. 34, of course, it is there, but that is a different thing altogether, challenging the award part. These 3 sections, 9, 16, and 17, is during the continuance of the arbitration proceedings we require day in and day out. And 37, of course, because appeal rise from these orders under section 37. That's why it is necessary. So before one goes to the framework of the section referred to above, it is necessary to understand the basic structure of the Arbitration Act. First and foremost, the matter being referred to under the Arbitration Act starts with section 7 of the Act, where it talks about an agreement with parties to submit all or certain disputes which may arise or which have arisen between them in respect of defined legal relationship, whether contractual or not. Therefore, first and foremost, there must be an agreement. The agreement has to be in writing, signed by the parties. The main crux of the arbitration proceeding is that there should be an agreement between the parties to refer the dispute to a choice arbitrator, or in case no agreement is arrived at, for the name of the arbitrator. Then, of course, Section 11 is available where you go to court of law and court appoints a named arbitrator. By consent of parties, you can agree before the court to appoint X person as arbitrator. If you still don't agree, the court, of course, has power to appoint an independent person as an arbitrator. Therefore, even for a court to decide that there is an agreement is necessary between the parties to refer the matter to arbitration. So, under Section 11, first the court will see whether there is an arbitration clause. If there is an arbitration clause, the court will refer the matter to arbitration. Now, it is not necessary that all times disputes should be referred to arbitration as defined under subsection 1 of Section 7. Itself uses the word all or certain disputes. So, it is not necessary every dispute at that particular time may be referred. For example, you have partnership action. During the pendency of the partnership, there is a dispute between partners on some accounts part or certain limited aspect of money part. That can be referred to arbitration because the word used in the section is certain or all. So you have got choice. You can. It's not necessary for you to refer everything at the time. So suppose, for example, you refer the issue of particular amount payable or particular dispute in the partnership action, and later on you dissolve the form or you want dissolution to be considered. So both can be done. It's not necessary everything should be done at a one particular time because strict rule of CPC though doesn't apply to arbitration, but some courts have held about order to rule to provisions, but it is still debatable. In a partnership action, when an arbitration agreement being available between the parties for any amount due, the partners or the property of the firm, is not necessary that only upon termination you should wait till termination and then file a suit. You can take up this issue and argue the matter. Therefore, when a section talks about all or certain disputes, it can be related to a particular time frame, like in instance given, a person can invoke arbitration of a property of the firm, accounts of the firm, and later on do about the termination and declaration that the firm is dissolved and accounts to be taken. So there are different stages of partnership also it can be referred to. Now, this is the agreement. So agreement, keep this in mind that first of all, agreement has to be in writing, signed by both the parties. It is not necessary that under the agreement, everything at one go should be referred to arbitration. It can be staggered, deferred, depending on the situation of the matter. It can be done that way. If parties agree to an arbitration, fine, the name, or it can be referred to court of law. One more thing one must keep in mind that when you decide to name, because prior to 2015 amendment, there was no schedule 5 and 7. Now the schedule 5 and 7 have been amended, whereby you cannot refer to arbitration to certain persons named in a schedule. Suppose, for example, he is your ex-employee. You cannot refer the matter to such ex-employee under the amended Act, or is connected indirectly, directly with your organization. You can't appoint. Similarly, for example, a lawyer is appointed by you and he is connected, he is briefing regularly. You can't appoint such lawyer to be an arbitrator. So that is a ground where court can say that is biased. So first thing for appointment of arbitrator and reading schedules, you must keep in mind that whether on first principles can anyone think that this person might be biased because A, B, C, D, E, F, G reasons. If you have that in mind, that this person can be termed as a bias, then it's always better not to appoint such a person. But earlier, the state governments, public organizations, all were taking this into center and appoint their own ex-employees as an arbitrator and then continue. But after the amendment, this has gone. Now you can't appoint ex-employees, ex-officers as an arbitrator. The schedule it talks about it's a void agreement. Some people have taken the view, can we not do it by consent of parties? Consent of parties, you can do it. But the question would arise that for some reason, if you have to challenge that award, you cannot then say that this arbitrator was biased because it's your knowledge. You knew that this arbitrator was connected one way or other with either party, and still with open eye, if you decide to appoint him as the arbitrator, then you cannot take up the contention of biasness. Now, keep in mind, whenever you want to appoint an arbitrator, you must see that he is completely independent and not connected with either parties. So there's no ground for have more biasness. So that one thing you must keep in mind whenever you decide to appoint arbitrator. Now, therefore, first is arbitration appointment. The next question comes in: how do I protect my properties? Section 9 was a very wide section which comes into operation before, after, or during the pendency of the arbitration. So, this section 9, you can go to court of law and get an injunction, protect the properties where you want to protect, or appoint a receiver. All these blanket powers which the court had otherwise in civil procedure code were given under section 9 of the Arbitration Act. But what is to happen that normally person move section 9, don't move invocation, they only get appoint receiver, injunction, and then slip over the rights. The other side is affected by that. Because you have not invoked the arbitration. You only, before also you can do it. The section provides you can move section and before also. The person would move before and then slip tight with the invocation. Therefore, in 2015, an amendment was brought that within 30 days of the order, you have to invoke arbitration. You can't slip tight with the order. So, therefore, under section 9, though it is before invocation, but invocation is necessary within 30 days period of the order being passed under section 9. Section 9 also gives a power to go during the pendency of the arbitration. Now, this was there because at that particular time, prior to 2015, section 70 was not amended. Therefore, section 17 did not give powers to the arbitrator to appoint a receiver, grant injunction. All those powers which are vested in the court was not available with the arbitrator at that particular time. Therefore, the wording of section 9 was even during. After the amendment of 2015, 17 section was amended, but still the legislature in its wisdom did not remove the word during from section 9. So it still remains. The question is then, when can an order be passed? If a matter is pending in 17, can you go to 19? 9. The court will say, look here, if I find that my passing an order is in clear conflict with the order passed on the 17th by the tribunal, I will not interfere. It is the rarest of rare cases where the court feels if the order passed by 9 will not interfere with the order passed on the 17th, the court may interfere. Or if the court finds, because under 17 the order is passed, your remedy is to go to 37, change that order. You can't go again to the High Court. But certain remedies, the High Court feels that this ought to be done for the protecting the property. In such circumstances, in rare cases, the arbitral tribunal's order will also be simultaneously passed by under section 9. Otherwise, section 9 will be totally redundant once the arbitration commences and invocation takes place, the arbiter is appointed. Then his powers will be under 17 only. Therefore, nowadays, the court has started a system. As soon as section 9 application is made, the court appoints the arbitrator, refers the matter to arbitration, and under 17 gives all powers to the arbitrator to decide, keeping all the contentions open and without prejudice by all the parties. So, therefore, that is also permissible under section 9. Section 9, if an order is passed, right to challenge is under 37. So, that persons can challenge the order under 37 of the Act. The question which arises after this is 17. I wanted to show you one more thing, that 9 gives wide power to the court. It can appoint guardian for minors or a person of concerned mind for the purpose of arbitration proceedings. Pass interim measures in respect of preservation of any property or goods, securing the amount, detention, preservation of subject matter of arbitration dispute. It can order any person to enter upon land or a building to verify the correct situation at site. It can pass an interim injunction order or appoint receiver, but subsection 9.2 gives the widest power to the court for interim measures by using such other interim measures for protection as it appears to the court just and convenient. Therefore, apart from the specific powers given in 9.8e, the court has full powers to go further and pass special orders. Unlike 142 of the Constitution, the Supreme Court can pass any order which is in the interest of justice. Similarly, 9 gives that wide power to the court to pass an order for protection of the property apart from what has been given in the section itself. Section starts with the heading interim measures. What it presupposes that it is to provide only interim measures. It is not a permanent order. It only protects the property during the adjudication of the proceeding before the tribunal. In Millennium Gas Agency versus TVS Finance, the Madras High Court held that an interim order to sell immoral property was without jurisdiction nullity and amount to grant of all time permanent measures. So basically, keep this in mind that as far as Section 9 is concerned, it is an interim measurement. So once if it is an interim measurement, no order can be passed by any court of law which will amount to a final order. For example, the court is been asked to allow the property to be sold at the interim stage. If the property is sold at interim stage, what remains the final decree or award? The person will be left high and dry who succeeds. Therefore, that type of order where it contains finality cannot be passed under Section 9. So keep in mind that whenever you move a court under Section 9, you have to keep in mind that it is only for interim measures. It is not in a nature of final decree. Similarly, under 17 also, the arbitrator passes an order is only interim measures. It is not a final. Unless you ask the arbitrator that you pass an interim award. Interim award is a totally different ballgame altogether that has nothing to do with the regular passing of the order of protection of the property. Interim order can be in rupee and in pi also. Suppose, for example, a person has admitted claims of 5 crore rupees and in a reply or letter, he has admitted 2 crore is due and payable. The contesting party can make an application, give an award of 2.5 crore rupees as interim award because they admitted document. That is a different thing altogether compared to the powers under Section 17 and Section 9. You cannot pass a final order. It is simply a measurement which has to be passed only during the pendency of the arbitration, nothing else. Now, the question were put with whether an interim stage of Section 9, the court can grant specific performance at the interim stage, unlike in a suit. In a suit, you must be aware that court has a wide power. Court can pass at interim stage a decree also. But that power is not vested in the arbitrator. Because Section 9 does not talk about passing of a specific performance, grant of specific performance itself is the nature of final decree. So this, because I am seeing day in and day out, people have been making application of Section 9 of these type of reliefs. This cannot be granted under Section 9. Even asking material amounts, they are the respondent directed to pay rupees so and so to me. That cannot be done under Section 9. This can't be unless you say and you make out a case like Order 3825 Civil Procedure Code, you make out a case that person is going to run away, protect his money, deposit. You make out a case under 38.5, similar case which you are required to make out. Then in such circumstances, of course, the court will pass an order interim measurement protecting you by asking him to deposit the money in court, or if you're feeling that he's running away from the country, ask him to deposit his passport in court. All these measurements can be passed by the court. Otherwise, nothing else can happen towards final decree. The next question that arises is interim order passed by 9 affecting third party who are not parties to the arbitration agreement? The situation might arise where the court might pass an order affecting third party. In a given case where order is passed against third party who is claiming or deriving a title to the party to an agreement, in such case, endeavor is made by the party to the agreement to frustrate the contract or to come out of contractual obligations. In value advisory service versus on Delhi High Court has passed an interim order framed in such a manner which prevents abuse and affect the third party. So in a given case, for example, a third party is in possession of a property. The dispute is going between A and B for the purpose of that particular property. For giving effective decree, the third party might be asked to intervene. Earlier, there was no question about third party getting right to intervene. Any order passed against that third party by this arbitral tribunal will be nullity qua him, because he is not bound by the agreement, he is not a party, and neither he is claiming by or under any party to the agreement. There was such third party, no order can be passed against that third party. It is only third party who is directly or indirectly connected with the dispute, and by virtue of getting full decree, his presence required or his requirement of his agreement is to be considered. Then, such circumstances, of course, the order can be passed against that third party. Otherwise, where third party is concerned, no orders can be passed without giving proper hearing. The next question about arises in which I am going day in day out in the court. Can a court pass an order restraining invocation of bank guarantee? If such applicant under Section 9 before granting injunction not to engage bank guarantee, the court will have to consider the terms of the contract, the manner in which the guarantee is invoked. If the bank guarantee is unconditional, payable on demand, then the bank is liable to pay. Normally, the court would show slow down in granting injunctions in this bank invoking bank guarantees, because bank guarantee is a separate transaction, and the court should not interfere with the underlying transaction between the parties to the proceeding. There have been Supreme Court judgments on that. And therefore, while granting, though power vested in the court to grant such relief under Section 9, but the court will be cautious enough to grant any such relief if it's not falling within the parameters of the Supreme Court judgment on invocation of the guarantees. Now we come to consider Section 17. These powers, which have been now made applicable to tribunal, came with amendment with effect on 23rd October 2015. Prior to the amendment, tribunal did not have the wide powers of appointment receiver or securing the amount. These powers are analogous to the powers of court, and therefore section itself states that arbitral tribunal shall have the same power of making the orders as that of the court for the purpose of and in relation to any proceeding before it. In view thereof, though Section 9 permits application to a court during the pendency of arbitration, but with these wide words, the powers being given to a tribunal 9(3) of the Act states as thereabout that court shall not entertain an application of Section 9(1) after the constitutional order tribunal unless it finds that circumstances exist. So under 17, there is a provision made that court will not interfere under Section 9 if the court finds that it will not that the order passed by the tribunal is not contrary to law. An order passed either under Section 9 or 17 can only be challenged by petition or application under 37 of the Arbitration Act. The tribunal under 17 can pass an order to enforce negative covenant in the contract as stated by Apex Court in Gujarat Bottling versus Coca-Cola. It must be kept in mind that no covenant can extend beyond the term of the contract and is void under Section 27 of Indian Contract Act. One more question would arise in our mind whether pending arbitration bank or financial institution can simultaneously resort to the provisions of SARFAESI Act for taking action of enforcement of security. Delhi High Court in MD Frozen has held that it was not obligated on bank and financial institutions to withdraw proceedings before tribunal prior to resorting to secure its interest under the SARFAESI. So it is permissible. Prior to amendment of Section 17 orders, the tribunal did not have power or authority to enforce measures. However, as per Subsection 2 of Section 17, after amendment, subject to any order passed in appeal under Section 37, any order issued by a tribunal will be deemed to be an order of the court for all purposes and shall be enforceable under CPC. They were now the order passed by the tribunal under Section 17 is enforceable like an order of the court. It must be noted that under the Act there is no provision for second appeal. After disposal of appeal under Section 37, therefore revision is maintainable against order under 37 as held by the apex court in Sham Sundar Agarwal. But there is no second appeal from an order passed under 37. You can go under 136 to Supreme Court by SLP. That's a different thing altogether. So this is how the whole framework of Section 9 and Section 17 are covered under the Act. Both have got similar powers. Both have got appointments, one to arbitrator, one to the court. Both do not conflict with each other and are in fact complementing each other. So that should be kept in mind. Now, the next section I turn to is Section 16. Section 16 deals with the ruling of the tribunal on its own jurisdiction. It has power to give ruling on any objection with respect to existence, validity of the arbitration agreement. For that purpose, the arbitration clause shall be treated as an agreement independent of other terms of the contract. The decision by tribunal that the contract is null or void shall not entail ipso jure the invalidity of the arbitration clause. It must be also kept in mind that challenge to jurisdiction under Section 16 should not be raised later than submission of the defense. So, as you have said, you are aware in the court also, if you want to take up the contention of jurisdiction, you must take up the contention prior to filing of the written statement. Same principle applies over here, that as and when you want to take the issue of jurisdiction of Section 16, try to do it before the statement of defense is filed. It must also kept in mind the challenge jurisdiction section is not raised later than submission of defense. It also must be noted that merely because the party itself has appointed, now this one more important aspect is that merely if you have appointed an arbitrator by consent or you have taken part in appointment of arbitrator, it does not preclude you from not challenging the appointment itself. That is the main important thing in Section 7, because people are under the impression that if I myself appoint an arbitrator, I consent to the arbitrator, now how do I challenge it? It happens that you may not be knowing certain things at a given time when you consent to an appointment of arbitrator. But then you come to know about the particular thing or a relationship with that arbitrator with the other party or something. It is open for you to come out to the case in Section 12 and say, this I feel my bias because ABCD reasons. And therefore I'm challenging the jurisdiction. Or while going through the documents, everything you come to know that the jurisdiction is not wasted in him. This arbitrator's appointment is wrong. You can always challenge that. Though you have taken part in his appointment, you have also consented to it. So that you must keep in mind. It is not closed door for you if you have appointed an arbitrator yourself also. Only thing is, arbitrator appointed by you in ad hoc arbitrations, divorce the court is one part of it. When you get the arbitrator appointed by court also under Section 11 and you consent to an order being passed, you can still get the order varied from the court by making a proper application, giving reasons why you want arbitrator to change. That power is vested in the court. So you're not powerless. You can go to court and say, I don't want this arbitrator for ABCD reasons, though I myself have consented, but these are the reasons. If the court finds ground justifiable, the court will definitely appoint a new arbitrator. The tribunal under Section 3 of Section 16 has got power to condone delay. The tribunal prior to apex court judgment were not giving ruling immediately on Section 16 and kept the issue pending till the final hearing of the proceedings. Earlier, what used to happen is that you file a Section 16 application, it will not be heard for months together, years together. Supreme Court came out with a view, the arbitrator should give a reasoning or give a finding. No doubt, arbitrator too shrewd enough. They found out a way. There's a mixed question of law and facts involved. It will take time. We'll decide the time of final hearing. Because what happens is Section 16 order cannot be challenged in between. You have to wait till the final award comes in, and you can only challenge by way of Section 34. So in any event, if you have challenged that, you have succeeded also, you have to wait for the final award to come in. And therefore, parties agree that let the arbitration person go ahead and finally let the arbitrator decide whether. And sometimes what happens genuinely, is a mixed question of law and facts, where the arbiter at the threshold cannot decide. Then in such circumstances, the arbiter no say. For example, you take up a point of limitation, or you take up a point that the whole claim is a stale issue. Now, whether it's stale or not, prima facie you cannot decide, because it might be on the basis of the letters, it might be on the correspondence, it might be basis of the intra-party minutes, meetings. All these requires evidence. And therefore, at that juncture, the arbiter might say that this question, I can't decide this threshold, I require evidence, it's a mixture of law and facts. At that time, some of the arbiter tribunals have started doing this. Under section 16, they have started recording evidence. And after recording evidence, they come to conclusion whether jurisdiction is there or not, and then decide. And if they have, then they continue the further proceedings. But some arbitral tribunals do that, some don't do that. It all depends upon the tribunal consent of parties. One thing, as far as Arbitration Act is concerned, everything is by consent of parties. It's an agreement between the parties which runs the entire act. So main thing is that this agreement. Even the clauses of the sections of the arbitration also says, unless party don't agree, other party agree. That even your procedural part has to be agreed between the parties. If you don't agree, then arbiter can fix his own procedural part. If the parties agree to a particular procedure, the arbiter has to follow that procedure. So all this, keep in mind that entire Arbitration Act is based on an understanding and agreement between the parties. Now, Section 16 is a mandatory, not with an agreement between the parties. In the apex court, in 7 judges judgment, SBP has given ruling on its own jurisdiction and existence of the arbitration clause, available only to the arbitration constitute without intervention of the court under Section 6, except in case of the court finds that it is not possible that state to decide whether the claim is live or not. Therefore, what happens is, when SBP came into power, that gave a ruling that the jurisdiction of the court arbitrator can be decided by the arbitrator himself, though unless the court has given reasons. So nowadays what happens is, when you 11F6 application are made before the court may not decide the validity of the agreement at that particular stage and leave the issue open to the arbitrator to decide. If that issue is kept open for the arbitrator to decide, then of course the arbitrator will decide under Section 16. But if the court comes to a conclusion that there is a valid arbitration agreement and therefore I am appointing XYZ, then there is no question of Section 16 application on jurisdiction. Therefore, because the court itself in its wisdom has decided that there is a valid arbitration agreement, based on that valid arbitration agreement, I am appointing XYZ arbitrator. I am not talking about independence of that arbitrator person. I am talking about the basic principle that once the higher court appoints the arbitrator coming to conclusion that agreement is valid and subsisting, then there is no question of arbitrator tribunal going back into issue and hearing 16 application. At that stage, 16 application will be barred. You can't go back to the same thing unless the court has left that open issue with the arbitrator to decide. When a question of fraud is raised, the same has to be considered differently, as fraud wishes all aspects. However, bold plea of fraud, coercion, collusion is not enough. You have to prove that. Unless you prove that, you cannot challenge the jurisdiction of the arbitrator. These various judgments are there on site, which you can consider. Therefore, what I would like to submit to all of you is this: that friends, keep in mind that you are the master in this Arbitration Act to decide how and in what manner you want to proceed with the arbitration with consent of other side. Form up your own procedural aspect. Section 16 should be applied as early as possible. Do not wait till even filing of the SOD, till the other side files SOD. Immediately you must move that. Challenge the award if you want to challenge it immediately. The order passes on 17 to the High Court. So all these powers are wasted. This is how the Arbitration Act is completely covering it. Thank you and oblige.
Please, sir, your voice is not audible, sir.
There's something wrong with the net here.
Right. Now it's okay, sir. Now it's okay.
Yeah. Thank you, Mr. Sharma, for giving me this opportunity.
Please, sir. Sir, you have concluded, sir?
Yes.
Anybody want to ask any question? Anybody wants to? Sir, if somebody is not ready to ask question, I can ask one question. It's very relevant, sir. Sir, in terms of the Public Premises Act, we used to, the order is passed under section 4 and 5 in Public Premises Act, and the appeal lies in section 9 of the Public Premises Act. Once the order is passed in Public Premises Act and the order is challenged before the learned district judge, so the judge has not decided the matter of appeal, whether the same should be granted or not, and in between the High Court appointed arbitrator under section 11(6) of Arbitration Act. The arbitrator is appointed. So the one should withdraw the appeal from the learned district judge, or he or she should file the application under section 17 of the Arbitration Act before the learned arbitrator.
The question is the person who has got order in its favor.
The other party has the
Correct. Other party has moved 11 application.
Yes.
So the person who is having an order in his favor,
yes,
can ask the court under section 9 that please stay this arbitration proceedings because this is happening. No order should be passed by section 7, or you can say the same thing to arbitrator also. No order should be passed on 17 till this matter has been issued. It's a sub judice, it's already been decided by competent jurisdiction.
Right.
There should not be any conflict of two opinions, because that court is a court of competent jurisdiction. And if the court of competent jurisdiction has passed an order, though it is under challenge, but that order is not on the ground of competence. If the court order is on the ground of merits, the challenge will be on the ground of merits.
Right.
So if that is the issue, then there's no question of arbitration and giving two separate same finding by two different courts.
But Public Premises Act order.
It's a special enactment.
Yes, it's a special, right.
So it's a special enactment with full powers to decide the issue. So the question is, under what provision, how and what ground was 11(6) applied?
The arbitration clause was there. That was the reason it was applied.
No, arbitration clause between whom?
With both the parties.
Who are the two parties? Who are the two parties before the court?
Defendant.
No, that is always there. But who are the two named persons?
A and B, sir.
Correct, but that is not the authority. The authority is not before the court on 11(6). Public Premises Eviction Act is on the authority which passes the order finally.
Yes.
So it's an authority which passes an order. So that party is not before the court. They have not made that party a party, because the party is only between the licensor or licensee or that type of things.
Right, sir.
So that is a different thing altogether. Unless the court is apprised of the fact that there is an order already passed by the Court of Commercial Jurisdiction and there will be conflict of interest, the court will not interfere.
That's really wonderful.
That is pointed out to him, because the idea is to avoid multiplicity of proceedings.
Right, sir.
So unless that is taken care of, there is no end to it. Right. So either you bring this to the notice of the court under 11(6), you can bring notice of the tribunal under 17.
Right.
The tribunal or the court in its wisdom will decide whether to interfere or not to interfere, because if the order is correct and it might affect the third party rights, because there the government rights are affected. If the Public Premises Eviction and the order is passed to hand over possession of the property, and any order is passed by arbitrator, contrary to that, it will be a different mess up issue. This can be done.
Right. Anybody wants to ask anything from sir? Any question? That means everybody is satisfied, sir, and everybody is absolutely okay. And next time, whenever we will have the session 2 of this Arbitration Act, we will have the question answer session especially, and we will convey the same to all the audiences, all the young lawyers, that they may ask questions. And really, thank you very much, sir.
Thank you very much.
LAWVS, thank you very, very much. Thank you, sir.
Thank you to all my learned friends.
Thank you to all who have joined for this very nice session. Thank you very, very much, sir. Thank you, sir.
Thank you.
Thank you, sir.
Thank you.